An actionable misrepresentation is a false statement of existing fact or law which induced the party to enter into the contract. In a limited number of circumstances, a failure to disclose a matter may be treated as misrepresentation. Misrepresentations may also be contractual terms. The potential remedies for misrepresentation are a rescission of the contract and damages. The right to rescind can be lost. The amount of damages, if any, will depend upon whether the misrepresentation was innocent, negligent, or fraudulent. Damages may be available at common law for the torts of deceit or negligent misstatement. The Misrepresentation Act of 1967 also provides that damages may be awarded for misrepresentation. Where a party attempts to exempt liability for misrepresentation, this attempt will generally be subject to the test of reasonableness in the Unfair Contract Terms Act of 1977. When negotiating a contract, the prospective parties may say many things which are designed to encourage the other party to enter into the contract. Sometimes these statements become terms of the eventual contract. If they do not, a remedy may nevertheless be available to a party who has been induced to enter into the contract in reliance on a falsehood. After the Misrepresentation Act 1967, there are now much more extensive remedies in damages available for misrepresentation. Under Section 2 of the Act, and Section 1 provides that a contract may be rescinded for misrepresentation even if the misrepresentation is also a term of the contract. For a misrepresentation to be actionable, it must be a false statement of existing fact or law. A statement of opinion is not generally a misrepresentation. See Bissett v. Wilkinson from 1927. Two exceptions exist. The first is where the person expressing the opinion is aware of facts which indicate that the opinion cannot be sustained. See, for instance, Smith v. Landhaus Corporation from 1884. The second exception, which can lead to a statement of opinion being treated as a false statement of fact, is where there is evidence that the person making the statement does not believe it at the time that it is made. Proof that the maker of the statement was aware of contradictory facts may prove that they did not believe the statement was true. See Edgington v. Fitzmaurice from 1885. Traditionally, statements of law were not regarded as being statements which, if false, will give rise to remedies for misrepresentation. It seems, however, that now that the House of Lords has recognized the possibility of restitutionary remedies for mistake of law in Plainward Pension v. Lincoln City Council in 1999, the same approach may well apply in the area of misrepresentation. If the statement of law is not believed by the person making it, then the principle in Edgington v. Fitzmaurice will apply, so that the statement will be treated as a misrepresentation of the person's state of mind. In order for a misrepresentation to be actionable, it must induce the person to whom it is addressed to make a contract. This means that the statement must be one of the factors which led the person to enter into the contract, but it doesn't have to be the sole or main reason. See Edgington v. Fitzmaurice from 1885. The representation must play, however, a real and substantial part of the claimant's decision to enter into the contract. See Redgrave v. Heard from 1881. If the misrepresentation would have induced a reasonable person to contract, the court will assume that it did so induce the representee to contract in this instance. Misrepresentation by silence. A misrepresentation generally requires an oral or written statement. There are, however, some exceptions to this. First, it is clear that in certain situations, conduct may be treated as implicitly making a statement. If the implicit statement turns out to be untrue, then it may be a misrepresentation. See Spice Girls Limited vs. Aprilia World Service from 2000. Secondly, where a statement which was true when made becomes false as a result of a change of circumstances, keeping silent may be treated as a misrepresentation. See, for instance, With vs. O'Flanagan from 1936. Additionally, there are some contracts which are treated as being of the utmost good faith or uberrime fidei. This means that parties are obliged to disclose relevant information even if it's not asked for. See, for instance, Lambert vs. Cooperative Insurance Society from 1975. There are four different categories of misrepresentation which relate principally to the state of mind of the person making the statement. Fraudulent. The maker of the statement knows or believes that the statement is untrue or makes it not caring whether it's true or false. Negligent at common law. The maker of the statement and the person relying on it are in a special relationship, giving rise to a duty of care under the principles of Hedley-Byrne versus Heller from 1964, and the maker of the statement acts in breach of this duty. Statutory misrepresentation. The maker of the statement has no reasonable grounds for believing it to be true. Section 2.1 of the Misrepresentation Act of 1967. See also Foster versus Action Aviation Limited from 2013. Innocent. The maker of the statement genuinely believes it true and does not act negligently at common law or under the statute in making it. The distinction between these categories is vital in determining the remedies which may be available to the person relying on the statement. The remedies available for misrepresentation will depend on whether it was made innocently, negligently, or fraudulently. There are potential remedies available under the common law, both in contract and tort, and under statute, with the Misrepresentation Act of 1967. The main categories of remedy are first, rescission of the contract, and secondly, damages for losses resulting from the misrepresentation. Rescission. The principal common law remedy for a misrepresentation which induced a contract was rescission. This was, and is still, available whether the representation was innocent, negligent, or fraudulent. Rescission in this context means that the contract is set aside and the parties put into position where they would have been had the contract never been made. Any goods or money which have been exchanged must be returned. The remedy of rescission must be sought by the claimant. It does not occur automatically. Misrepresentation renders a contract voidable rather than void. There are some situations where the right to rescind will be lost. The right to rescind is lost where a party to a contract, aware of the other's misrepresentation, continues with the contract and thus affirms it. See Long v. Lloyd from 1958. Additionally, where there is a significant lapse of time between the making of the contract and the discovery of the misrepresentation. See Leaf v. International Galleries from 1950. The right to rescind is also lost where restitution is impossible. Since the idea of rescission is to restore the parties to the position they would have been in had the contract not been made, if property which has been transferred has been consumed or inextricably mixed with other property, rescission will not be permitted. See Clark v. Dixon from 1858. Finally, where rescission would affect the rights of a third party, rescission may be lost. The most obvious example is where goods have been sold to the misrepresentor, who has then sold them on to an innocent third party before the contract has been voided. Damages. The common law was late in recognizing a right to damages for non-fraudulent misrepresentations. An innocent misrepresentation provided only an indemnity for necessary expenditures incurred as part of the contract rescinded by way of monetary compensation. See Whittington v. Seal Hain from 1900. Where a misrepresentation is fraudulent, damages may be recoverable under the tortious action for deceit. This requires the claimant to prove that the statement was made knowing that it was untrue and without any genuine belief in its truth, or with a reckless disregard for whether it was true or not. See Derry v. Peake from 1889. The law of tort in Hedley-Byrne v. Heller from 1964 eventually recognized that the negligent misstatement which caused economic loss could be actionable. The action that has developed from this provides another potential remedy for the person who has entered into a contract as a result of a negligent misstatement from the other party. The most important innovation in the Misrepresentation Act of 1967 was the introduction of the action for what is generally referred to as negligent misrepresentation in Section 2.1. In fact, the Act does not use this terminology, but provides that a statement which would form the basis of an action in deceit, if made fraudulently, will also give rise to liability, unless the person making it is able to prove that he had reasonable grounds to believe, and did believe up to the time that the contract was made, that the facts represented were true. On the burden of proof, all that the claimant has to do is to prove that the misrepresentation was made and that it induced the contract. The defendant would then be liable for damages under Section 2.1 unless he can prove that there were reasonable grounds for his belief that the statement was true. See Howard Marine v. Ogden in 1978. As regards the measure of damages, the most important authority is Roy Scott Trust v. Rogerson from 1991. Here it was held by the Court of Appeal that damages under Section 2.1 should be calculated in the same way as if the statement had been made fraudulently. Section 2.2 of the Misrepresentation Act provides a discretion for a court to award damages in lieu of rescission where it was judged equitable to do so, taking account of the effect of rescission on the parties. The exclusion or limitation of liability for misrepresentation is dealt with by Section 3 of the Misrepresentation Act 1967, as amended by Section 8 of the Unfair Contract Terms Act of 1977. This requires that any clause which attempts to limit liability for misrepresentation must satisfy the requirement of reasonableness set out in Section 11 of the Unfair Contract Terms Act. See Aurora Fine Arts Investment v. Christie from 2012. Broad attempts to exclude liability have been found to be unreasonable even if the clauses are drawn from widely used standard conditions. Sometimes the attempt to exclude liability is put into the form of an assertion, for example that no statements are made other than those contained in the contract itself. Such entire agreement clauses have been considered in a number of cases. Although there is an early authority on the Unfair Contract Terms Act version of Section 3, which held that such a clause could be effective to restrict liability for statements made by an agent of the party concerned. This is Overbrook Estates versus Glencombe Properties from 1974. Subsequent cases have taken the line that an entire agreement clause or clauses which attempt to deny that there is any reliance on pre-contractual statements do not fall within the scope of Section 3 as far as liability for misrepresentation is concerned. See Cramdian Properties versus Nash from 1977. In other cases, however, courts have concluded that clauses which seek to define the applicable duty are outside Section 3. See Watford Electronics versus Sanderson from 2001.